pointing at me to get in the camera. I didn't know I was going to be on video today, but I'm so super excited about that. Okay, I'm going to talk to you guys about direct examinations. What's important about direct exam? Blue. Tell me. That's an important part. You cannot lead your witness. What is the essential part of direct examination? Why is it so important to your case? Right there. Uh-huh.
Making your witness look friendly, more likable, more
Excuse me.
being best friends with your witness, making them look higher up.
That's part of it. For me as a trial attorney, direct exam is the most boring part because you have to let your witness be the star. So you're essentially there to guide your witness along in terms of telling the story. The most important part about direct examination that you all need to understand is most trials are not won upon your opponent's pitfalls, but upon the strengths of your own case. So direct examination is your opportunity to display those strengths through your witness. Direct examinations have to be clear. What do I mean by that? Anybody? There.
They can't be all complicated and confusing. Like you're on one topic and then you just quickly transfer to another one. So what happened that night, and then what happened like 9 years later?
That is very important. Your direct exam has to be logically and organizationally thought out. That is key. You don't want to be hopping from one subject to the next because your jury's going to be like, what are you talking about? You were just talking about a murder. Now we're talking about a car. You want to logically organize your direct exam so your jury can easily follow you. First and foremost with any direct examination is you want to personalize your witness, first of all. What does that mean? Camo. Exactly. First and foremost, you want to introduce your witness. You want to personalize that witness by telling what's your employment, what do you do, are you married, are you not, do you have children, if that's relevant to the case. So your jury can get a feel for who this person is. That's very important because the jury getting a feel for who your witness is going to determine whether or not they think this witness is actually credible. So it's your job as the attorney to first and foremost organize your direct examination, which allows you the opportunity to personalize that witness up front. Your theme, Ty talked about this a little bit, your theme and your theory, your buzzwords you want to use in your case are important in your direct examination. You want to make sure you've weaved those through in your direct examination. I was talking to Clinton just a little bit ago, the team Clinton, and their buzzword was what last year? Did you use that in your direct examination? How?
When directing Pierce Ivory, we would say, Miss Ivory, how were you affected by the incident that Morgan Pettigrew has caused? She would respond with, it completely shattered my dreams. I had an outstanding future, and I had so much to live for, but it was broken like glass.
Okay. And you use that shattered dreams in your opening. You use that in your direct exam. You use that in your closing, I'm sure. So that was a key point for your jury to focus on, the shattered dreams. Okay? So that's very important. If you've got a theory or a theme or a buzzword that you're using, make sure you're weaving that through on direct exam with your witness. Overall, you want to keep your direct examination simple. Why is that?
Always assume that the jury will be ADD, ripped off to something else. And if you start getting complicated, go off.
Yeah, that's true. And you also want to keep it simple because what could happen on cross-examination if you don't keep it simple?
And they can kind of interpret like anything you say. Like they could be like, they could twist your words pretty much.
If you don't keep it simple, then you're giving more ammunition for opposing counsel in cross-examination. So you want to keep that down to who, what, when, where. I'm getting directions about where I'm going and where I'm not going. You want me over here? Is that better for the video? Okay. So you want to make sure it's who did you see that night? What did you see that night? Where were you that night? Those sorts of things. Okay? So it's simple. It's logically organized so that you are making sure you're going chronologically from your introduction of your witness into your undisputed facts, then going into the story that you're trying to tell. Okay? A general logical sequence I typically like to use with my witnesses is obviously your personal background. You're setting the scene. You're telling the story initially. Then you want to have the primary focus, the meat of your direct examination is going to be that action description of what happened. So you walked in and found the body. Where was it lying? How did the body look? Was it close to the desk? Those sorts of things. That's going to be your action sequence, and that's probably the most important part of your direct examination. Then you are obviously going to introduce your exhibits through your direct examination. Are exhibits important in direct examination? Why? Tell me why. Score points. What else?
They can build foundation upon the witness's statement.
That's exactly right. If you've got an exhibit to back up what your witness is telling the jury, that is going to make your witness look more credible. So use your exhibits. Use lots of them if you can. However, you want to be careful with your use of exhibits. Don't overload your jury with a ton of exhibits. When you're using an exhibit with the witness, do not have your witness read verbatim from the exhibit. You want to hit the highlight of an exhibit and move on to your next exhibit. Don't hand them a 10-page document and say, hey, can you find the paragraph in there that says he killed so-and-so? What's your witness going to do? They're going to sit there and read the document, which is going to be incredibly boring, and you're going to be like, oh my goodness, how do I get myself out of this pickle? Don't do that. If you've got an exhibit you want to use, have it highlighted in some manner, point your witness directly to that, have them hit that highlight, and move on to your next exhibit. Don't bore your jury. Your final issue that you want to cover on direct examination is typically your damages or the ultimate catch in your case. For example, if you're doing a murder case, you would say, okay, Officer Dixon, when you walked in, where was so-and-so's body lying? What position was it in? What wounds did you see? Those sorts of things. So you want to hit your major point at the end. You don't want those? Oh, thank you. These are some rules for you guys for your witnesses. First of all, your witness needs to be competent about the case. Why is that? You're exactly right. You go on direct examination, your witness is the one that's telling the story. It's not you, the attorney. It's your witness. So you want to make certain that that witness is very competent, very versed in the facts of the case. So that means a lot of prep time, but you guys are going to have a lot of prep time. So you want to make certain that they're competent about the facts, how you're going to organize your direct examination logically, and how that's going to flow. So you're not having a witness up there who's surprised when you switch from where was the car to where was the body, okay? You want to prep your witness for how that's going to flow. Next, what kind of questions can you use on direct examination? You guys have talked about this a little already. Excellent. Black hat. Open-ended. Non-leading. Can you use compound questions? Why is that? It's an objectionable. Plus, if you ask your witness, a compound question where you're calling for them to add 4 or 5 facts at a time, your witness could get confused. And if your witness gets confused, you're going to get confused, and you're going to figure out how you're going to get out of that problem. So you want to keep it to who, what, where, when, and why. Always open-ended. Why are open-ended, again, so important? Because your witness is telling the story. You want your witness to tell the story, not you tell the story. You guys need to know what to include and what to exclude. Use your topical organization that we already talked about. When we talked about putting the action part into your direct examination, what does that mean to you guys? Anybody?
Do you revert the question?
Say it again.
Do you revert the question? Repeat it, please.
When I say you want to put your action into your direct examination, what does that mean? You want to ask your witness about the action part. Camo. Okay. Like, when did you find the body? Where did you find the body? What did you see happen? If you are going through a direct examination with your witness and they are giving you the action part of describe what you saw or describe what you saw him do, something of that nature, do not interrupt that story. That is always key on direct examination. That action part is always what the jury's going to hang on to, what they're going to pay attention to. Should you use good facts before addressing bad facts? Anybody have an opinion on that? You're all over the place answering these questions. Anybody else over here? Yeah. Say that again. You're saying use the bad facts first because the good facts could distract them? Well, I have a different take. I use the good facts first before addressing the bad facts. Does anybody have a reason or reasoning why I do that? You, right here on the end.
Many people stop listening after the first 10 or 15 facts that you throw out there, and so they may not hear the bad things that you say at the end.
Exactly. I focus and play up those good facts as much as I can, then I throw those bad facts in there really quickly and get out. And hopefully the jury, as we all have established, they have a little bit of ADHD, will still be back there thinking about those good facts instead of those really quick bad facts that I threw in. How do you want to end your direct examination? Good. Let's be more specific.
Like a really precise question that would kind of make your witness like look the best that they can.
Okay. What else?
Typical positive question that kind of summarizes what you want out of it.
Good.
Don't end on an objection.
Throwing in on an objection? Don't end on an objection. That's a good point. You always want to end your direct examination with the clincher, with something that's very important, a key fact that's going to be stuck with your jury as you walk away and someone comes up for cross-examination. Okay, so if we're talking about, for instance, where the body was laying, you want to end on that point. If that's a key fact in your case about where the body was laying, end on that fact. Leave that with your jury. You guys have any questions real quick for me?
So what's the best way to like let your witness out of the jury without doing like the objection that they're good?
Use your open-ended questions. Who, what, where, when, and why. You're not leading your witness. You're not using compound words. You're not typically asking for a hearsay. And if you're throwing in your exhibits that you've laid the foundation for, that allows your witness to flow through and tell the whole story without you being interrupted continually by an objection. Anybody else?
What's an example of a bad fact?
A bad fact would probably be if your witness, who's supposed to be really credible, has been convicted of arson 3 times or something of that nature. Okay? You want to quickly get that in there and get right back out.
How would you quickly get a bad fact like that?
Do what?
How would you quickly get a bad fact like that?
You could say, for instance, what's your criminal background? He's going to say, I've been convicted of arson 3 times. You're going to say, okay, we're moving on. So where did you find the body? Or something of that nature, okay? Or when you're laying out your background for your witness, lay out all the good points about your witness, ask that one quick question, and move right on. Because they're going to bring it up in cross-examination. Would you rather them bring it up in cross-examination, or would you rather address it in direct? Would I publish?
Do you publish exhibits during when you're talking about them or after?
It depends on what exhibit you're using. If it's really a key exhibit like a diagram of a home where you're saying the body was found, you want that to go to your jury so they're looking at that while your witness is telling the story. Okay, one more. Give you an example of a leading question? Leading questions. Give me one.
The car was blue, wasn't it?
Exactly. A leading question is a question that suggests the answer in the question. So you want to avoid those when you're on direct because you will absolutely get an objection to that. Okay, I'll be back later to talk to you guys about closing.